Hello, I'm Scott Crook of Crook and Taylor Law, also known as the Utah Employment Lawyer. Today, in our next installment of the Utah Employment Law Quick Tips, we are going to be discussing the Families First Coronavirus Relief Act, which was signed into law last night by President Trump. The Act's provisions will become effective in 15 days or on April 2nd, 2020. And the question that we're going to be discussing is what leave must employers give to employees now that Congress has passed the coronavirus emergency legislation. The Act applies to two types of employers. The first is any employer who employs fewer than 500 employees, and it also applies to any governmental employers. The law requires that the employer provides sick leave, or paid leave is a better way to put it, to any employee who becomes sick because of COVID-19 or who is placed in quarantine because of COVID-19. It also requires the employer to provide leave to an employee who is providing care to somebody who's been quarantined or who is sick because of COVID-19. Now, it makes a differentiation in how much an employer must pay based on how the leave is granted. If the leave is for the employee's own sickness or quarantine, then the employer is required to pay 100% of the employee's salary for up to 80 hours, but no more than $511 per day. If the leave is to care for a person in that situation, then the employer is required to pay 2/3 of that employee's wage, up to $200 per day. Now, the legislation also amends the Family Medical Leave Act and requires these same employers to provide paid family leave to an employee who is, first of all, employed for at least 30 days. So it extends the reach of the Family Medical Leave Act. And it requires the employer to pay 2/3 of that employee's salary if the employee is unable to work or telework due to a need for leave to care for a son or daughter under 18 years of age, if the school or place of care has been closed or the child care provider of that person or daughter is unavailable due to COVID-19 or an emergency declared because of COVID-19. Certain employers are exempt. Those employers are healthcare providers or emergency responders. And also, Congress has instructed the Department of Labor that it may exempt employers of less than 50 employees if providing the leave will cause them to go out of business, essentially. It also provides penalties for any retaliation against an employee for using the leave. It also requires employers to post notices, which will be provided within 7 days. And it provides that employers will be reimbursed through credits on their quarterly payroll tax filings. If the credit doesn't fully reimburse the employer, then they will be cut a check. That's, in summary, what the law requires. Of course, as you know, the law changes and there may be regulations, and the law may be different as it applies to you. And so the information in this video may be outdated or it may not apply to you specifically. So The information is not intended as legal advice. Please check with a competent attorney to apply it to your specific circumstances. We would be happy to answer any specific questions that you may have, and you can contact us at the contact information provided on this slide. Thanks.